When an ultra-high net worth marriage ends, the financial outcome can swing by hundreds of millions of dollars based on a single jurisdictional decision made before a lawyer even speaks in court. In this environment, litigation is not a debate over fairness. It's an aggressive race to establish control over which laws will apply to the estate. To see the scale of this impact, we can look at the divide between litigating in Manhattan versus litigating in Sao Paulo, Brazil. New York applies equitable distribution, giving judges discretion to weigh individual contributions to determine a fair split. Brazil follows a rigid fractional split, dividing marital assets 50-50 with no flexibility. The exact same estate yields staggered, wildly differing final valuations. Tracking these numbers is difficult because the ultra-wealthy use complex, multi-jurisdictional asset protection structures designed to keep wealth out of reach once a legal separation begins. Prevailing in this environment relies on 4 distinct legal maneuvers: rapid accelerated service, anti-suit injunction orders, aggressive asset framing, and structural immunity. The first move is initiating the suit with enough speed to establish the preferred court's timeline. Most international cases are slowed by the Hague Service Convention. This treaty requires routing translated documents through a foreign central authority, a bureaucratic process that creates a massive bottleneck. This chart shows how the traditional Hague process stalls litigation for up to 6 months. Litigants can bypass this by petitioning for alternative service. If a spouse evades notice, judges may authorize service via email or social media, instantly locking in the start date. Filing first, however, does not guarantee jurisdictional control. U.S. courts follow the doctrine of comity, which means they will often defer to a foreign court's decree to maintain international harmony, but only under specific conditions. The court must find that the foreign matter has reached res judicata, or absolute finality. The ultimate strategic objective is not simply who files first, but who secures a final, unappealable judgment first. The New York case of Bourbon versus Bourbon demonstrates this requirement. In this case, New York recognized a French decree because the time for appeal had passed. This finality barred the spouse from pursuing separate equitable distribution claims in the United States. We see the inverse in the Cahen-Vorberger decision. Because the French judgment was still under appeal, it lacked res judicata. The New York court refused to grant comity, allowing the U.S. litigation to proceed as if the foreign ruling didn't exist. Since the goal is crossing the finish line of finality first, you must deploy tactics that actively freeze the opponent's momentum in their preferred court. When a spouse begins racing ahead with proceedings in a hostile jurisdiction, the court must be asked to intervene. The most effective countermeasure is a Hague injunction. A Hague injunction does not bind the foreign court itself, as that would violate international comity. Instead, it is an in personam order directed at the spouse, legally forbidding them from advancing their foreign suit until the primary court decides on jurisdiction. This pause holds the litigation level long enough to ensure one side doesn't steal a march in a different country. While legal teams fight over the venue, there is an immediate risk that the opponent will hide or liquidate assets to keep them out of the eventual settlement. This is addressed through a worldwide freezing order, often called a Mariva injunction. To secure this, you must prove there is a good arguable case and a real risk that the assets will be dissipated before a judgment can be reached. These orders pair with disclosure orders, compelling the spouse to provide a list revealing the nature, value, and location of their holdings. While powerful, they aren't self-executing. They require initiating secondary recognition proceedings in the countries where the banks and offshore entities are located. A Hague injunction stops the legal clock, and a worldwide freezing order locks the capital. Together, they ensure the board remains unchanged until final judgment. Stalling a foreign court is merely a procedural shield. The core of the defense is the legal architecture of the wealth of self. If the jurisdictional battle is lost, you may face a civil law court demanding an automatic 50% split of offshore wealth. Most high net worth individuals believe a traditional Anglo-Saxon trust will prevent this outcome. However, in many civil law jurisdictions, a trust is not viewed as a separate legal entity. It is categorized as a personal relationship between a settlor and a trustee. Civil law courts exploit this by piercing the trust structure. They use clawback mechanisms to invalidate asset transfers or declare the entire structure a sham if the spouse retained too much control. These concepts date back to Roman law and forced heirship provisions, which were designed specifically to prevent individuals from hiding assets from their family members. The structurally superior alternative is the private interest foundation. Unlike a trust, a private interest foundation in Panama or Liechtenstein possesses separate legal personhood. It is a distinct entity that owns the assets in its own right, separate from the founder. Panamanian law, for example, contains specific statutes that explicitly reject foreign matrimonial judgments and forced heirship claims. Because the assets belong to the foundation and not the individual, they are effectively immune to standard international clawback attempts. Success in an international divorce is determined by speed of initiation, the weaponization of injunctions, and the use of uncompromising structural armor.